Did you know that brandishing or pointing a firearm in New Jersey requires a mandatory prison sentence if convicted? Well, we had a client who was involved in a road rage incident and was alleged to have pointed a loaded firearm at the other driver. It didn't spend a day in jail or a day in prison. You want to know how we did it? Hi, I'm Daniel M. Rosenberg. I'm a criminal defense attorney and the founding partner of Rosenberg, Perry & Associates. It is also my personal goal and passion to provide information and education about the criminal justice system before individuals become involved and entrenched in the system. And working as a criminal defense attorney has put me in a very unique position to advocate and argue on behalf of people. And it's not necessarily arguing that they are innocent, but arguing that whatever crime they committed, the punishment is not suitable. And it puts us in a position to argue for the best interest of the client. And this case is a perfect example of that. So let me tell you a little bit about who this person is and what the circumstances were. So this individual is in his mid-70s. He was traveling in New Jersey with a loaded firearm in his vehicle. He did that for safety reasons. But he had that firearm in his car illegally because he did not have a permit to carry that firearm. And this case took place before permits to carry were really permissible here in New Jersey. He was allegedly involved in a road rage incident where he pulled out a firearm and pointed a loaded firearm at another driver. He drove off, was subsequently pulled over by the police. They searched his vehicle, they found a loaded firearm. He was subsequently charged with 3 crimes in New Jersey. Unlawful possession of a weapon, a crime of the second degree, possession of a weapon for an unlawful purpose, a crime of the second degree. He was also charged with aggravated assault by pointing a firearm. Worthy of note, as I've talked about in other videos, 2 of these charges are second degree crimes. That means they come with a presumption of incarceration. What that means is, if convicted, you go to prison. After he was charged, unfortunately, he did not seek legal representation. He stuck his head in the sand for over a year, ultimately was indicted, and then he sought representation from our office. So, what did we do once we were retained? Well, the first thing we did was we brought the client in, we gave him an honest assessment of the case. And that was that he is charged with a crime of the second degree that has a presumption of incarceration. And if it can be proven, this is a state prison case. We told the client, you need to have realistic expectations of what the exposure is, but we're going to do everything we can to fight scratch and claw to get the best possible result. And if we can avoid state prison, that is absolutely what we were going to try to do. But we also needed the client to know that this was a fight. The next thing we did is we contacted the prosecutor and opened up the lines of communication, let them know we were representing the client, and asked for all discoverable materials. After we obtained the discovery, the next thing we did was learned everything we possibly could about our client. And what we found out was he was a disabled war veteran. He was honorably discharged after serving in Vietnam. He was also a law enforcement officer for over 2 decades. He also served as a certified nursing assistant and did a lot of volunteer work. He was also physically disabled and needed the assistance of braces to walk. The next thing we did was confirm all this information. We got medical records, character letters, past employment documents, everything to establish that what we were going to argue and present to the state was true. Finally, we distilled all of this down into a concise and persuasive correspondence that we provided to the prosecutor. We sent that to the prosecutor and made our argument that this individual was worthy of a break. And the closing line of that letter reads, "The defendant, at 76 years of age, has lived a law-abiding life, served his country and community, and while doing so, has been exposed to substances which have harmed his health. This one error in his exemplary life should not result in his having to spend possibly the end of his life in prison." And that's because if he were to go to prison, he would in all likelihood not live long enough to make it out. So what's the end result? After digging in and making this presentation to the prosecutor and continuing to follow up and reiterate all of the positive aspects of our client's life, we were able to convince the state to amend these charges to a 4th degree illegal transportation of a firearm, a non-custodial, non-prison, non-jail sentence. He ultimately pled guilty to that amended charge and served a period of probation with no issues. This was a life-altering resolution for the client, and he was absolutely elated that he didn't have to spend a day, much less years, in prison. And we were grateful to be a part of this resolution. So if you or someone you know has been charged with a crime in New Jersey, firearms related or otherwise, please contact our office. We're happy to help. We'll set up a consultation. We'll take the time we need to assess your situation and give you blunt and candid advice. And if you liked the contents of this video, please like or subscribe to our YouTube channel. And if there's a topic you'd like to learn more about, please contact our office or leave a comment below. I'm happy to hear about it. We are criminal trial attorneys. We have your back. That's what we do.